Hello everyone, welcome to IASBABA's 60 days rapid revision series for Prelims 2022. This is day 50 and we are taking up polity topics. So some of the topics like the constitutional and statutory bodies we will discuss here, and before going to that we will take up the guessworks. So here, which one of the following is a filter feeder? So again friends, if you know the filter feeder, even then you can't answer this question. Say for example, you type all these in Google. So all of them the Google will show as filter feeders only. So here the most appropriate ones is the oyster because it is exclusively filter feeder. So but that became a knowledge. So within the examination constraint, you cannot attempt this. So as I said, the questions which are shortest, so they are the toughest ones and you cannot take a guess for them. So better leave this question there. And if you have the knowledge of these, so you will have your luck and you will have your day in this question. Then come to next. In case of which of the following biogeochemical cycles, the weathering of rocks is the main source of release of nutrients. So here again, it is a simple NCERT related question. Say for example, the carbon dioxide. So that is the main source for carbon cycle, and carbon dioxide is present in atmosphere. And then nitrogen dioxide. Again, that is the famous source for the nitrogen cycle. And then for the sulfur cycle, we have sulfur dioxide. But for phosphorus cycle, we should require the phosphorus pentoxide, and this is rarely present in the atmosphere, and this is a very heavy molecule, so that it is very difficult to be formed. So hence most of the phosphorus cycles nutrients, they come from the weathering rocks and not from the atmosphere. So again friends, by reading NCERTs, so the copy paste question will not come, so the application level questions will come. So apply whatever basic you study to the surroundings and then attempt the question. Then come to next. The common carbon metric supported by the UNEP has been developed for which of the following? So here friends, a guessing mind will go likewise. Like the carbon metric. Metric is something, a matriculation, and matriculation means something, the measurement. So here we will search for those words which will depict measurement. And here we can see assess means measurement, but assess is not present only in A, it is also present in C and it is also present in D. So hence here knowledge only can rule, the guesswork cannot rule here. So again we can leave this question, but however if you have gone through the 1 week 1 website program which we had discussed, so here it is like in the UN environment website we can get this global common carbon metric approach. So here again we can skip this and then come to the next one. Which of the following have species that can establish a symbiotic relation with other organisms? So friends, here we know that in biology we haven't discovered many of the species at all. So many of the marine terrestrial species, they are not at all being discovered. And how you can say that something will not have a symbiotic relation at any cost? So somewhere without our notice, so if it is having, so it is a true statement. So that is why go with the inclusive approach and hit all of the above. So all these at any part of the world, so they can have a symbiotic relationship. So 1, 2 and 3 will be the formidable answer. So these are today's guesswork. Then come to next. Affinity test and identification of scheduled tribes. So affinity test is used to shift through anthropological and ethnological traits to link a person to a tribe. So to what extent a person is having affinity to a tribe or a community. So that is the very meaning of affinity test. Then Bombay High Court in Shilpa Vishnu Thakur case, so it accepted the relevance and importance of the affinity test. And the court said that affinity test was an integral part of verification process for the caste certificates. And then the term affinity meant association of the applicant for a caste certificate with the scheduled tribe into which he or she has been born. So again, to what extent he is affiliated or to what extent he has affinity. Then, however, currently Supreme Court is no longer confident in an affinity test that is used to sort through anthropological and ethnological traits to link a person. So here contact with other cultures, then migration, then modernization are likely to have obliterated a tribe's traditional characteristic. So all these have disturbed that affinity. So again, there is a need to come up with any other novel approach. And after realizing that the courts were faced with the differing opinions about the efficacy of affinity test, so the very effectiveness of affinity test was doubtful, and the Supreme Court decided to refer the case to a larger bench. So whenever Supreme Court comes up with any other formidable solution, so we will update with that. So here remember what is affinity test and where it is used. So that is more than sufficient for us. And then the National Commission for Protection of Child Rights. So this commission was established by the Commission for Protection of Child Rights Act 2005. So remember the parent law under which it is established. Then the commission works under the aegis of Ministry of Women and Child Development. So this is an obvious fact. Then as defined by the commission, child includes persons of the age of 18 years. So mark this 18 years as important because recently we have changed that. And then the commission is mandated under section 13 of the CPCR Act 2005 to ensure that all laws, policies and programs, so they owe allegiance to the constitution and also for the UN Convention on the Rights of Child. So for two things they have the allegiance, that is the constitution and the UN Convention for Child Rights. So we remember that. Then the composition of this Commission for Protection of Child Rights. This commission has a chairperson and 6 members, of which at least 2 should be women. So remember this one, and all of them are appointed by the central government for 3 years. Friends, this word central government is being repeatedly appearing in the prelims. So they are appointed by the central government. So if again the word comes for this organization, so we will take it as a correct statement and not as a vague statement. Then the maximum age to serve in the commission is 65 years for chairman and 60 years for the members. So but obvious for chairman it is more. And then come to next, the Island Development Authority. So it was constituted under the aegis of Union Ministry of Home Affairs in 2017 for the development of islands. So mark Home Ministry as important one, and Island Development Agency is chaired by the Union Home Minister. Again but obvious. Then the members include Cabinet Secretary, Home Secretary, then Secretary Environment, Forest and Climate Change, then Secretary Tourism and Secretary Tribal Welfare. So remember friends, so except Home Minister, so all others are secretaries, so the ministers are not included here. And then this will undertake holistic development in various islands and also giving importance to its diversity, that is biodiversity and eco-diversity. Then Niti Aayog has been mandated with the task to steer the holistic development of the islands in sustainable manner. So this Island Development Agency will work under the supervision of Niti Aayog as well. So this was all about Island Development Authority. And then Council of Scientific and Industrial Research. Friend, this is in news in the wake of vaccination for COVID-19, hence it becomes important. So it was established by Government of India in 1942 as an autonomous body. So remember it was established before independence. And now it has emerged as the largest research and development organization in India. And although it is mainly funded by the Ministry of Science and Tech, it operates as an autonomous body under the Societies Registration Act 1860. So remember the Ministry of Science and the Societies Registration Act. Then the activities of CSIR include aerospace engineering, structural engineering, ocean sciences, life sciences, metallurgy and others. So in varied field, the research and development is undertaken in this council. Then who is the president of this council? Prime Minister happens to be the ex officio president, and then the vice president, but obvious, the Minister of Science and Technology. Then the governing body. So this council consists of a governing body and it is headed by the Director General. So he looks into the day-to-day administration and other policies. Then the other ex officio member is the Finance Secretary. So Finance Secretary looks into the financial management. And this governing body has an advisory body also. So that is consisting of 15 members and they come from varied fields. And here the members of this CSIR advisory board, they enjoy a tenure of 3 years. So here at least remember the president, vice president, then the governing body and the advisory board. Then come to next, the National Commission on Safai Karmacharis. So this commission was constituted in 1994 as a statutory body by the National Commission for Safai Karmacharis Act. So remember the act friends. So here we have the Manual Scavengers Protection Act as well. So that act doesn't give the National Commission for Safai Karmacharis. This act gives. And then it comprises of the chairman who is in the rank and status of Union Minister for States. So a person who is equivalent in position to the Union Minister of States, so he will be the chairman, and 4 members including a lady member in the rank and status of the Secretary to Government of India. So after Ministry of States, so next 4 members will be the secretaries. Then any person who is in the rank of Joint Secretary for the Government of India, he will act as the secretary to this commission. So remember the chairman and 4 members and the secretary. Then come to next. As per the provisions of Prohibition of Employment as Manual Scavengers and the Rehabilitation Act, the NCSK has been assigned the work to monitor the implementation of the Act. So this Act doesn't set up the National Commission, but all the powers for the commission is taken up by the Manual Scavengers Prevention and Rehabilitation Act. So remember the role of this act, it is very much crucial. That is why I brought it here. It will not establish the commission, but it will give the powers for its functioning. Then the functions of the commission is to tender advice for its effective implementation to the center and states, to the effective implementation of what? Of this act, and then inquire into the complaints regarding contravention or non-implementation of various provisions of the act. So it will advise and also inquire in case of any violations and contraventions. Then the National Security Act. Friends, in the name of National Security Act, many persons have been detained, so that is why it becomes important. So under the NSA, a person is taken into custody to prevent him or her from acting in any manner prejudicial to the security of the state or for maintenance of public order. So here security of the state and public order are the two main reasons why a person will be arrested under the National Security Act. Then it is an administrative order passed either by the divisional commissioner or the district magistrate and not detention order by police based on the specific allegation or a specific violation of the law. So friends, remember this National Security Act is not working under the preventive detention law. So under preventive detention, the police will order an arrest, and here the divisional magistrate or the divisional commissioner is ordering the arrest. Then even if a person is in police custody, the DM can slap the NSA against him. So whenever he is slapped with the NSA, so all other rules or laws for the purpose of which he is actually arrested will cease, and the National Security Act's clauses will take into effect from then on with this person. So that means the NSA will be having overriding effect with other laws related to arrest and detention. Then, if a person has been granted bail by a trial court, he then be immediately detained under the NSA. So even if a person is on bail, so he can be re-arrested under this NSA. So again we can see how the overriding effect is being playing. And if the person has been acquitted by the court, the same person can be detained under NSA. So even if a person is acquitted by a court, he also can be arrested. Then the law also takes away an individual's constitutional right to be produced before the magistrate within 24 hours. So in case of any detention except preventive detention, the police should submit the accused to the court within 24 hours. So even that law ceases its operation once the NSA comes into picture. Then the detained person also does not have the right to move a bail application before a criminal court. So even the bail, which is otherwise a right, also cannot be applied in this NSA. And also the DM who passed the detention order is protected under the Act. There is no prosecution or any legal proceeding can be initiated against the official who carried out the orders. So that means the district magistrate or the divisional commissioner will be having complete immunity over the orders he passes in compliance with the NSA. Therefore, the writ of habeas corpus is the only protection granted. So friends, here we can see the National Security Act has overriding powers on almost all the laws of arrest and detention that are existing in India. But however, the writ of habeas corpus is the only protection guaranteed under the Constitution against the unchecked state power of taking people into custody under the NSA. So this is the only solution, that is habeas corpus. And one crucial procedural safeguard is the Article 22 Clause 5, where they have the right to make an effective representation before an independent advisory board, which consists of 3 members, and the board is chaired by the member who is or has been the judge of a high court. So that means the Article 22 Clause 5 will also provide a safeguard, that is, this case under the NSA can be taken up and can be petitioned in front of an independent advisory board, which is headed by a person of the current or retired judge of a high court. So here we have only 2 solutions for the NSA, that is habeas corpus and the advisory board. So if you remember that, that is more than sufficient. Then the Weapons of Mass Destruction and their Delivery System Amendment Bill 2022. So this bill seeks to expand the existing 2005 Act to include a ban on funding of weapons of mass destruction. So there is a complete ban on the funding of weapons of mass destruction under this 2022 Amendment Bill. And it also empowers the central government to freeze and seize the financial assets of people involved in such activities. Then the weapon of mass destruction is defined as any nuclear weapon, radiological chemical weapon, then biological weapon or other devices that has capacity to inflict death and destruction on a massive scale. Then examples include missiles, nuclear bombs, and after the 9/11 attack, So even the passenger jets, so they are also considered as the weapons of mass destruction. So remember the 9/11, it is the Twin Towers blast. Then the need for this, that is the United Nations Security Council, so that has come up with a targeted sanctions for all the financial institutions which will finance the production of the weapons of mass destruction. So this UNSC is taking up the charge now. So as a compliance for that, Government of India is amending its laws as well. And then the recommendations of the FATF have mandated against the financing of proliferation of weapons of mass destruction and delivery system. So if India doesn't amend its laws, so under FATF, we will also be blacklisted, just like Pakistan. So that is why UNSC and FATF. So these are the two driving force for India to come up with this amendment bill. So that is what about the bill. Then come to next, minimum age of marriage. So friends, we know that we had increased the minimum age of marriage for the girls from 18 to 21. So here the point of discussion is in which all the laws that amendment has been brought in. So we can always get a question in prelims like which of the following laws have been amended when government came up with this initiative. So here for the Hindus, the Hindu Marriage Act is amended, and here the 18 years is removed and 21 years is replaced. And this is same for the Christians, and even in the Christian Marriages Act, the replacement has been taken up. And then in Islam, the marriage of a minor who has attained puberty is considered valid from now on. So here for Islam, there is no particular law, hence there is no full-fledged amendment per se. And even in the Special Marriages Act and in the Prohibition of Child Marriages Act, the amendment has been brought in. And apart from that, even in the Juvenile Justice Act, the amendment is brought in. So remember the Hindu Marriages Act, then the Special Marriages Act, Christian Marriages Act, then Prohibition of Child Marriage Act and the Juvenile Justice Act. Then come to next, the Noise Pollution Regulation and Control Rules. So friends, nowadays we have been hearing about the loudspeakers in temples, masjids, etc. So what is the actual institutional framework we have? So that is what we need to study. So here the National Pollution Control Rules, so that stipulates some decibels of sound so that are permitted in one area. Say for example, in industrial area, 75 decibels per day and 65 for night. And in commercial areas, 65 in day and 55 in night. And residential area 55 and 45, and silent area 55 to 40. So the silent zone is an area comprising not less than 100 meters around the hospitals, educational institutions, courts, etc. So silence area is where the silence is a demanding criteria. So friends, when we study all these, so remember that the sound is measured in terms of decibels. So as a matter of science and tech, we remember that fact as well. And then the Rule 5 of the Noise Rules 2000 restricts the use of loudspeakers or public address systems. And the Rule 5 was amended in 2010 to restrict the use of sound producing equipments also. In all these cases, a written permission is necessary for using such equipment. So here, mark this as important. So if you don't have written permission, so the loudspeaker are not allowed. Then district magistrate, police commissioner and other officer, so not below the rank of deputy commissioner of police, are implementing authorities under the noise pollution rules. So but obvious, they will be the implementing agencies in the ground level. Then the state government has been empowered to grant permission to the use of loudspeaker on the cultural or religious festivities, and that too with some reasonable restrictions. So on the basis of this, several Supreme Court judgments have also been taken up. So Supreme Court also gave a sweeping judgment on this noise pollution, and they said that anything which pollutes the noise is not at all allowed. But however, we should do it with the warnings and awareness approach, not all of a sudden. So this is the legal status of noise pollution for us. Remember decibels and various stipulations here, and also remember that this noise pollution rules, so that comes under the Environment Protection Act. So that if you remember, it is more than sufficient. Then Greater Tipra Land. So several tribal outfits in Tripura have joined hands to push their demand for a separate state for indigenous communities in the region. So just like the Greater Nagalim, the Tipra Land is also coming up, and they want center to carve out separate state under Article 2 and 3 of the Constitution. And what does these two articles say? Article 2 of the Constitution deals with admission or establishment of the new states, and the Parliament may by law admit into the Union or establish new state on such terms and conditions as it thinks fit. And Article 3 comes into play in case of formation of a new state and alteration of areas, boundaries or the names of the existing states. Friends, you know that the President will take the opinion of the state, and the opinion is not binding, and after that the law is passed. So all those things will become important here. So friends, the doubt arises here is, so if the president is not bound by the advice of the state, then for what sake the advice is taken up? So here the advice is taken up on the basis of the democratic principles. So the very move of taking the opinion, so whether the opinion is heard or not is immaterial. So the very move of taking that opinion is itself a bonhomie between the center and states. So I am asking you before I take a decision. So that itself speaks volumes. So here we can say that the constitution in this article is giving the freedom of opinion to the states. And then coming to the matter of fact, Tripura was a kingdom ruled by the Manikya dynasty from the late 13th century until signing of Instrument of Accession with the Indian government in 1949. So remember the year in which the Instrument of Accession was signed. Then come to next, the Universal Service Obligation Fund. So this was formed by an Act of Parliament and was established in 2002 under the Indian Telegraph Amendment Act 2003. So mark this as important one, and it aims to provide financial support to the provision of telecom services in commercially unviable rural and remote areas. So basically to set up the networks, towers and others in the remote areas we require funds. So from where do the funds come? It is from the USOF, and it is an attached office to the Department of Telecom and is headed by an administrator who is appointed by the central government. So to manage the funds, there requires an administrative body, and that administrative body is an attached office to the Department of Telecom and it is headed by an administrator. And then the USOF is the non-lapsable fund, and the levy amount is credited to the Consolidated Fund of India. So whatever amount that comes, that is put into the Consolidated Fund of India, and the fund is made available to the USOF after the due appropriation by the Parliament. So here only after the Parliament's approval we can take the fund of USOF and use it. Then this was established with the fundamental objective of providing access to basic telecom services to the remote areas. So we know that. And then the resources for the implementation of USOF are raised by the way of collecting an universal service levy, which is 5% of the adjusted gross revenue of telecom service providers. So for every telecom service providers, after they pay the tax, so the income they are left with after paying the tax is the adjusted gross revenue. And out of that adjusted gross revenue, 5% is levied as the universal service levy, and that will go to the USOF. So remember the source of funding for the USOF. Then come to next, the delimitation of J&K. Friends, the delimitation commission's function is to form the electoral constituencies. And here a brief account of the commission. The commission has increased 7 assembly seats, that is 6 in Jammu and 1 in Kashmir region. And then 5 Lok Sabha seats are now made up of exactly 8 assembly constituencies, taking the total number to 90. Friends, now we have 43 plus 47, 90 assembly constituencies, and here these 90 assembly constituencies, they are divided exactly amongst these 5 Lok Sabha constituencies. Then 9 assembly seats will be reserved for the scheduled tribes, that is 6 in Jammu and 3 in Kashmir. And then the commission has recommended the provision of at least 2 members from the community of Kashmiri migrants, that is Kashmiri Pandits, in the Legislative Assembly. And the commission has also recommended representation in the assembly for the displaced persons from the Pakistan occupied Kashmir who migrated to Jammu after partition. So even for POK migrants, there is representation. So this is a brief account on the commission. And then coming to a brief history of the delimitation in J&K. So here constituency boundaries are being drawn only in J&K when the delimitation of the rest of the country has been frozen until 2026. So we know that in the constitution itself we have frozen this. So now only for J&K the delimitation has taken place. And the last delimitation exercise in J&K was carried out in 1995. And now after some 27 years we have taken up again. Then in the S12 state, the delimitation of parliamentary constituencies was governed by the Constitution of India, and that of the assembly seats was carried out by the then state government under the Jammu Kashmir Representation of People Act. So only for the parliament constituencies, the Delimitation Council of Government of India used to work, and for the state, the Representation of People Act 1957 of J&K used to work. So here Representation of People Act of India 1950-51 was not working, and after the abrogation of the J&K special status, so now the same delimitation commission of both assembly as well as parliamentary constituencies. Then come to next, the Law Commission of India. So it is currently defunct executive body established by an order of government. So remember, it is an executive body, not a statutory body. And currently now, no law commission is in existence. That is why it is defunct now. Then the commission's function is to research and advise the government of India on legal reform. And it is composed of legal experts and it is headed by a retired judge. And the commission is established for a fixed tenure and works as an advisory body for the Ministry of Law and Justice. So mark this as important, that is the advisory function. Then the first law commission was established under the Chartered Act of 1833. So that means the Lord Macaulay Committee. So that happens to be the first law commission of India. Then the first law commission of independent India was established in 1955 for a term of 3 years. And since then, 21 commissions have been established. So some important facts of numbers worth remembering. Then come to next, the fast track special courts. So cabinet approved continuation of 1023 fast track special courts for another 2 years. So friends, here these fast track special courts, they are being set up basically to resolve the gender violence related cases. So here these FTSCs are dedicated courts expected to ensure swift dispensation of justice, and they have a better clearance rate as compared to the regular courts, and they hold speedy trials. And besides providing quick justice to the hapless victims, it strengthens the deterrence framework for the sexual offenders. So speedy justice is itself a deterrence. And the continuation of 1023 fast track special courts aims in reducing the gender violence and the rape cases and the POCSO cases. So here remember the fast track courts which are established basically to resolve the gender violence cases. Then to bring more stringent provisions and expeditious trial and disposal of such cases, central government enacted the Criminal Law Amendment Act 2018. So these fast track courts are established under this Criminal Law Amendment Act 2018. And this act made the provision of stringent punishment including the death penalty for the perpetrators of rape. So remember this fact. And then this led to the establishment of the fast track special courts, as we have discussed, and the central share of these courts is to be funded from the Nirbhaya Fund. So here remember the Parent Act which gives birth to the fast track courts, and also the funder, and also the purpose, and also the death punishment that is being amended. Then come to next, the electronically transmitted postal ballot system or the ETPBS system. So this has been developed for the convenience of service voters. So for the persons who are indulged in the election duties, so for them this is a facility to vote from distance. And the Conduction of Election Rules 1961 allows service voters to vote using the ETPBS. So remember the rules under which these ETPBS are being established. And the ETPBS is developed by the Election Commission of India with the help of CDAC. So as it is the electronic form, the CDAC comes into picture. And postal ballots are sent electronically to the registered service voters under this system. So the ballot goes in the email mode, and the service voter can then download the ETPB and then register their mandate, that is put the vote or put the seal and mail it to the constituency's returning officer. So once he puts the vote, so he will send it via post for the constituency's returning officer. Friends, we know that returning officer is the head for that constituency. So he will head the counting process and he will declare the results. So for that person, so the post should be sent. Then come to next, it is secured system with a 2-layer security. That is, the secrecy is maintained through the use of OTP and PIN, and no duplication of the casted vote is possible due to the unique QR code. So this OTP and QR code, so these two are the double protection system. That means without OTP it will not get downloaded, and without the QR code we cannot take the photocopy of this ballot. Then the ECI proposed that this facility should be extended to the international voters as well. And the Law Ministry must amend the Conduction of Election Rules 1961 before it can be begun. So if we amend this, so even for the NRI voters, we can go up with the ETPBS. So these are some of the facts. Then coming to the last part. Friends, if you want to become a good leader or a civil servant, you have to think from the perspective of the common man. Say for example, if you are setting the policy for farmers, you have to become a farmer and think likewise. If you are setting a policy for the welfare of beggars, you have to become a beggar and think likewise. So ultimately it is like a good leader or a good civil servant. He should be able to bend his head even below the ground if he wants to win the hearts of the people. So a down-to-earth personality is the best suitable. So be as humble as possible. So shed all your egos and be as common as possible. And only then you become the uncommon person. So remember friends, it is the people who make you uncommon, not the you yourself on your own. So do it. All the very best. Good luck friends.